Welcome back to the Emily Show Monday edition, the quicker breakdowns of the law. Today, we have lots to talk about because the plaintiff in the Jay-Z and Diddy lawsuit gave an interview, which is now part of the court record because Jay-Z's lawyers immediately filed it as part of the court record and are asking again that the court dismiss this case and didn't waste a single opportunity to take some shots at the plaintiff's attorney. Plus, Diddy has given up the bail fight. TikTok is asking to be bailed out by the Supreme Court, but that is unlikely. Prosecutors want Tom Girardi to go to prison, and Tom Sandoval is now his own lawyer. What could go wrong? Let's get into all of today's stories. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. You may remember the name Tom Sandoval from Vanderpump Rules before the cast was reformulated and he was booted off of the show, or from Tom and Sandy's Restaurant, which is now closing. But Tom Sandoval, you may also know from the Scandoval of it all, where he had an affair with his longtime partner's close friend and both of their castmates, Rachel Leviss, who also on the show went by Raquel. Well, Rachel, with her attorney, Mark Garrigus, sued Tom and Ariana for a number of claims, all stemming from an intimate video that she says Tom Sandoval surreptitiously recorded over a FaceTime call. She did not know she was being recorded and alleges that Ariana distributed that. Though it seems from the facts of the case, Ariana sent that back to Rachel and said, "You're dead to me." This case is still wandering through the courts. Ariana has an appeal on a denial of her motion to dismiss and anti-slap motion. Tom Sandoval does not have an appeal, but he also does not have any attorneys at this point. He had previously fired Mark Garrigus's brother, who was representing him, after he filed a cross-claim of Ariana within the lawsuit. Of course, he said he was going to withdraw the cross-claim, and he did. And then he removed the Garrigus attorney from his legal team. Well, now he has filed a substitution of attorney on December 6, 2024, stating that he will now be his own attorney. I don't think this is a great idea unless he is on the precipice of settlement with Rachel. He indicated in previous news interviews that Rachel's attorneys had come to him and said, "Look, we won't sue you if you let us know," and point the finger at NBC Universal. What were they doing? And I've covered that in other content, but I wonder if they are on the precipice of settling or if this is a financial decision, given the fact that we know that Tom's restaurant is closing and he no longer has a show to fall back on, given that Vanderpump Rules is not going to be resuming with their former cast. So is it money? Is it a settlement? Is it a little bit of both? Civil litigation is expensive, and I can't imagine him choosing to go forward on this if a settlement is an option. So keep your eyes out for news that Tom has settled this lawsuit with Rachel, because I imagine that will be coming shortly. So just imagine the Jeopardy music in your head, because I'm sure YouTube would get cranky if I try to use it, but the time is ticking for TikTok. Remember, the legislation that bans TikTok unless it is sold and divested from its parent company goes into effect on January 19th, and that law has been upheld by the Court of Appeals. TikTok is now asking for an emergency injunction, and they are asking for the Supreme Court to take up this case. With regard to the emergency injunction, this is being filed in front of the same Court of Appeals that upheld the legislation that would effectively ban TikTok if it's not divested quickly, which is not going to happen. The sale is not going to happen in the next 3 weeks. They say petitioners move for a temporary injunction pending Supreme Court review. Absent such relief, the act will take effect on January 19th, 2025. That would shut down TikTok, one of the nation's most popular speech platforms, and its more than 170 million domestic monthly users on the eve of a presidential inauguration, like literally the day before. Before that happens, the Supreme Court should have the opportunity, as the only court with appellate jurisdiction over this action, to decide whether to review this exceptionally important case. And an injunction is especially appropriate because it would give the incoming administration time to determine its position, which could moot both the impending harms and the need for Supreme Court review. They say additionally that an injunction would impose no material harm to the government. There is no imminent threat to national security. That is particularly clear since Congress itself delayed the act's effective date for 270 days, and the government's own defense of the act at most asserts that China could engage in certain harmful conduct through TikTok. So they are asking the court to stay or enjoin this from going forward. The government has pushed back on this, saying, no, the act gave 270 days for TikTok to divest, and what they chose to do was fight this in court instead, so this must go forward. And we are also seeing the government fire back, saying that the only court that really could implement an injunction is the Supreme Court, because the DC Court of Appeals has already found the statute to be lawful law, and so they can't enjoin the law from going forward lawfully. So the government is saying, no, this needs to play out the way it's going to play out unless the Supreme Court intervenes. And we're already seeing lawmakers reaching out to Google and Apple, who run the app stores that carry TikTok, saying, remember, the deadline is upon us. So what will happen from here? Well, if you have TikTok creators that you adore and support, follow them on their other platforms. Find them on YouTube, Instagram. Do people still use Snapchat? Probably people younger than me. Find them on their other platforms if they are creators that you want to continue to support, because no matter what happens, the uncertainty on TikTok is going to hurt the creators that are on TikTok. Creators have also asked for an injunction in the DC Circuit Court of Appeal alongside TikTok, but it could very well be that TikTok gets pulled out of the app stores. Does that mean it will get pulled off of your phone immediately? No. Does it mean it will become a huge security risk because it will not be able to be patched, updated, there will be bugs, and it will become unusable? Yes, that is the most realistic path forward. But if you have not already downloaded TikTok, after January 19th, it's very likely that that will no longer be in the App Store. And then we will have to see what happens with things like TikTok Shop and advertisers on TikTok, because if TikTok is banned, putting money into it could create huge problems for companies. So yes, there is still some uncertainty, but I think it's pretty clear that this is going to come right down to the wire on January 19th. You know who shouldn't really be worrying about the TikTok ban? Tom Girardi. Why? Well, he's got bigger things to worry about. Disgraced attorney Tom Girardi and estranged husband to Real Housewife of Beverly Hills, Erica Girardi, is set to be sentenced on December 20th. Don't worry, I will update you on what that sentence is or whether that gets pushed even further into the new year. The federal government is asking for 14 years in prison for Tom Girardi. This conviction related to theft from 4 specific clients, but we know that there is still a pending action in Illinois that's going to depend on how he is sentenced here. And while we know that there were 4 victim clients that were part of the federal prosecution in California, we know that there are many, many more from the bankruptcy. So it is not unlikely that we will see Tom Girardi sentenced to some prison time. However, with federal sentencing, oftentimes there is a sentence and then there is a surrender date. So even if he is sentenced to prison time on December 20th, it is likely that the court will give him several months before he actually turns himself in. That is incredibly common in federal court and very common in nonviolent crimes. And speaking of people in prison, we got to talk about Diddy. In his extensive fight over bail, there have been more than 4 bail motions heard at the district court level in New York. But Diddy had also taken an appeal on one of the denials before it was reheard by Judge Submarinian. And that appeal had been on hold, waiting to see what the result of Judge Submarinian's ruling would be. And of course, he ruled that there are no conditions that would guarantee not only the return of Diddy to court, but the safety of the community. So what was going to happen with Diddy's appeal? Well, his lawyers just filed notice that they are not going to be pursuing the appeal on the issue of bail. This was filed in the appellate court on December 13th, 2024, docket number 242606, motion to dismiss the appeal pursuant federal rule of appellate procedure 42B2 and local rule 42.2. Appellant Sean Combs moves to voluntarily dismiss the appeal. It goes on to say this is an appeal from the district court September 18th order denying pretrial release on conditions and ordering Mr. Combs detained pending trial. Mr. Combs filed his notice of appeal on September 30th and filed a motion for bail in this court on October 8th. On October 17th, Mr. Combs filed a motion to hold the appeal in abeyance pending a renewed motion for bail before the district court. This court granted the abeyance motion on October 24th, 2024. On November 8th, Combs filed his renewed motion for bail before the district court. On November 27th, the district court denied Combs' renewed motion for bail. Combs does not seek to appeal the district court's denial of his renewed motion and hereby moves to voluntarily dismiss the appeal. Counsel has explained the effect of the voluntary dismissal of appeal, and Mr. Combs' signed Local Rule 42.2 statement is attached here too, which is I understand what I'm doing, and it is signed by him. I understand, and we are withdrawing the appeal. Why? Because it's a waste of time and energy when they are fighting on so many fronts. The fighting over his laptop, his ability to review his discovery, and what the federal government has access to is still ongoing, including a determination about the notes that were taken out of his locker when there was that custody sweep, and whether or not those notes were attorney-client material, whether they were work product material, or whether they were notes that are not due any privilege or protection. Those issues are still pending. And he also has a bunch of civil issues still pending, which is what we need to talk about next. But first, a huge thank you to today's sponsor, Factor. This is the time of year when things get incredibly busy and time feels like it speeds up, or at least it's that way for me. And one of the things I rely on when I am running around during a busy holiday season is food that is easy. Whether that's healthy or not depends on whether I have ordered my Factor meals. Factor has easy, nutritious options to keep you fueled and feeling your best, whether you like a routine or enjoy mixing things up. Factor has over 35 different delicious meals every week and over 60 additional convenient options that you can add to your box, like keto cookies, pressed juices, and smoothies. So even though it's busy this time of year, you don't have to sacrifice a healthy, easy meal while you're on the go. You can customize your menu preferences from maximizing your calories to vegan and vegetarian meals, or just a well-balanced, healthy meal to make sure you actually eat some vegetables. And Factor's meals are always fresh, never frozen. And what I love is that the boxes are flexible, so you can pick how many meals work for you in a given week, knowing how busy your schedule is. If you're ready to take something off your plate while keeping delicious food on your plate, it's time to head to factormeals.com/50QBLawnerd and use code 50QBLawnerd, like the quick bits, to get 50% off your first box plus free shipping. That's code 50QBLawnerd at factormeals.com to get 50% off your first box plus free shipping while your subscription is active. Let's get back to today's episode. Well, Jay-Z and his attorneys have been in the headlines quite a lot in connection to the civil suit that he was recently named in connection to a pending civil suit with Diddy. So they are now co-defendants in one of the many civil lawsuits facing Sean Combs. But you might have seen the headlines that the plaintiff in that case has admitted to making some quote unquote mistakes in her account per the headlines. Well, Jay-Z's lawyers didn't waste any time running to the court and saying, Your Honor, Your Honor, Your Honor, we have to talk about this case again. Do I think they did this to actually bring a motion in front of the court? Well, this isn't seemingly connected to anything except maybe the motion to dismiss. I think this filing is more to A, make this part of the record, and B, maximize the reach of this story because now it is part of the official court record. And of course, to take some shots at Tony Busby, the lawyer for the plaintiffs. So let's take a look at what Alex Spiro has to say this time. This was filed on December 13th, 2024, late in the day on Friday. Dear Honorable Judge Torres, we write to the court on behalf of our client, Sean Carter, aka Jay-Z, on a matter of extraordinary and grave importance for the integrity of the proceedings in the above captioned case. Today at 7:27 p.m. Eastern Standard Time, I told you this was filed late on Friday. NBC News reported on an interview that its reporters conducted with the anonymous plaintiff in this case. Footnote 1, and then footnote 1 points to the headline, Jay-Z rape accuser comes forward to NBC News, acknowledges inconsistencies in her allegations, and then a link to the article. They go on to write to the court, the interview outs plaintiff's allegations for what they are, a sham. They go on to write to the court, basic facts in her narrative, the who, what, when, and where are wrong. She claims her father picked her up after the assault. Her father denies that ever happened. She claims she spoke with Benji Madden at the party that night, but he was on tour in the Midwest at the time, forcing her to admit, I have made some mistakes. I may have made a mistake in identifying. And we're going to go to the full sentence because I suspect that that directly relates back to Benji Madden. They go on to write to the court, She claims the assault took place at an after party at Mr. Combs' home, but photos that night show Combs and Carter at the Lotus nightclub for an after party. When pressed, the plaintiff admitted she was guessing about key details, including the time it took to reach the venue. She admits she has no single corroborating witness over the last 24 years. Well, she said there were 3 people in the room, so they would all be defendants, except that Celebrity B, the female celebrity, might be a corroborating witness. I don't know if they would be a cooperating witness. They go on to write to the court, these stunning revelations make clear that the complaint filed by plaintiff's attorney, Anthony Busby, therefore has no factual basis whatsoever, which is required. They write, even Mr. Busby is walking back the complaint he put his name to, excusing these glaring inconsistencies by pointing the finger at the case being referred by another firm who allegedly vetted the story before sending it to them. This part, I have a lot of questions about. They go on to say the heinous allegations against Mr. Carter are patently false. The complaint filed by plaintiff's attorney Tony Busby, therefore, has no factual basis whatsoever. The heinous allegations against Mr. Carter are patently false. They just wanted to say that twice. They write, in light of these developments, it's now clear that Mr. Busby signed the complaints and other filings in this case in violation of Federal Rule of Civil Procedure 11. Under that rule, an attorney who signs a document assumes an affirmative duty to conduct a reasonable inquiry into the facts. They say that the attorney's signature denotes merit in the filing and, quote, sends a message to the district court that this document is to be taken seriously. In addition, attorneys who learn after filing a complaint that the factual assertions are false must immediately withdraw the claims. They go on to say, given today's revelations, Mr. Busby almost certainly failed to undertake a reasonable inquiry into the facts before filing the complaint. He should never have brought the claims. They say at minimum, he should withdraw them now. Allowing these claims to remain pending even a moment longer not only harms Mr. Carter, his family, his business, his employees, and his legacy. I don't know if the court will take that well. We'll see. They say it also impairs the integrity of the judicial system, thwarts the pursuit of justice, and silences the voices of true victims. That point is probably better taken by the court. They go on to write, furthermore, it appears that Mr. Busby has attempted to circumvent the authority of this court to enforce Rule 11 and associated obligations by declining to seek admission to this court before signing pleadings and other documents. Mr. Busby is not licensed to practice law in this court, and he has not yet sought, let alone obtained, admission pro hoc vice. So Tony Busby has not asked permission for the court to practice in that court. They go on to say, yet in the nearly 8 weeks since he initiated this proceeding, Mr. Busby has filed a complaint in this matter that was signed solely by him using a /S signature, signed the amended complaint alongside other counsel that added Mr. Carter as a defendant, and noticed a motion for plaintiff to proceed anonymously, accompanied by supporting brief and declaration, once again signed only by him, which means if there is local counsel on the cases, local counsel isn't signing these. An attorney not licensed to practice in the jurisdiction is signing those without permission from the court to appear. They go on to say most recently, on December 10th, 2024, Mr. Busby filed a letter, which he also signed alone. Busby's failure to obtain admission to the bar of this court is a transparent attempt to circumvent the basic requirements of Rule 11 and the rules of professional conduct. Admission subjects an attorney to the jurisdiction of the court and to sanctions for signing pleadings that are not grounded in the facts and the law. Footnote 1, which cites case law with regard to that. They go on to say Mr. Busby thus appears to have strategically declined to seek admission in order to avoid sanctions for a complaint that he knew had no factual basis. Also, I think there are 2 footnote 1s in this. Yes, there are. That should have been footnote 2, but okay. They go on to say, given these facts, Mr. Carter intends to file immediately a motion to strike the first amended complaint under Rules 11C2 and 12F and respectfully request the court shorten the filing deadline for that motion from 21 days to 1 day from the date of service in light of today's stunning public disclosures and the severe ongoing harm to Mr. Carter's reputation. So we know that there will be more motions forthcoming. As of the recording of this episode, Attorney Busby has not filed anything. Will we likely talk about this again in the coming week? Yes. So you need to make sure that you have the Law Nerd app. But there is an extensive article attached to this filing from NBC News that is the printout of the entire article that says Jay-Z rape accuser comes forward to NBC News, acknowledges inconsistencies in her allegations. The woman told NBC News she came forward because you should always advocate for yourself. When asked about inconsistencies in her account, she added, "I have made some mistakes." And then they go through the full article, which I will attach in the notes. I wanted to take a look more closely at what Attorney Busby said. The article from NBC says, quote, "I have made some mistakes." In her recollections of the night, the woman identified as Jane Doe in the lawsuit filed against Jay-Z and Diddy told NBC News. The woman said she stands by her allegations overall. The inconsistencies in her account of the incident alleged to have happened 24 years ago do not necessarily mean the allegations are false. It says among the inconsistencies, the woman said her father picked her up after the alleged sexual assault, but he says he doesn't recall that. Again, he might not recall it 24 years later. He might not. It goes on to say the woman also claims she spoke to a celebrity at the after party where she said she was sexually assaulted, but that celebrity said that he was not in New York at the time. Images from the evening showed Jay-Z, whose real name is Sean Carter, and Sean Diddy Combs at a different location than the one the woman described, although their whereabouts for the entire evening are unclear. In a statement Friday, Jay-Z told NBC News, quote, "This incident didn't happen, and yet he filed it in court and doubled down in the press," he added, referring to one of the woman's attorneys, Tony Busby. Quote, "True justice is coming. We fight from victory, not for victory. This was over before it began. This 1-800 lawyer doesn't realize it yet, but soon." Busby says he is continuing to vet her claims. Quote, "Jane Doe's case was referred to our firm by another who vetted it prior to sending it to us. Our client remains fiercely adamant that what she stated is true to the best of her memory. We will continue to vet her claims and collect corroborating data to the extent it exists. Because we have interrogated her intensely, she has even agreed to submit to a polygraph. I've never had a client suggest that before." Busby goes on to say, "In any event, we always do our best to vet each claim made, just as we did in this case. This has been extremely distressing for her to the point she's experienced seizures and had to seek medical treatment due to the stress." And in a statement to NBC, Alex Spiro says, quote, "It is stunning that a lawyer would not only file such a serious complaint without proper vetting, but would make things worse by further peddling this false story in the press. We are asking the court to dismiss this frivolous case today, and we will take up the matter of additional discipline for Mr. Busby and all the lawyers that filed the complaint." Well, they'd already asked for dismissal. They filed this letter to the court and said, "See, Your Honor, it should be dismissed." So they didn't really file for dismissal today, but hyperbole. They go on to say that Combs's attorneys called the suit a shameful money grab. And then the article goes on to remind the reader that Busby has filed more than 20 lawsuits against Combs. I will attach the article down below if you would like to read the entirety of the NBC article, but the lawyer fighting is not going to slow down with this interview being given. And I think this interview will probably make things more difficult for this case to proceed. What I have serious concerns about is the fact that Attorney Busby, who gave his press conferences saying how thoroughly they had vetted all the cases, is now saying, well, this one was brought to us by someone else and they vetted the case. That gives me a moment of pause about the attorney. Again, we will have to wait and see what happens in court, but we are going to see motions to dismiss. We are going to see Rule 11 sanctions motions against Attorney Busby, and this interview is going to speed things up rather than answer questions and slow them down. And with that, thank you for being here for the quick bits. I will see you around the YouTubes for more legal breakdowns this week. Don't forget to subscribe to The Emily Show on your favorite audio app. We have some audio-only episodes coming for you over the holidays, and make sure you have the Law Nerd app so you stay in the loop with everything that's happening in the law. And I will talk to you soon. So thank you for being here. Thank you for being a Law Nerd, and may the odds be ever in your favor. Cheers. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.